This video has been made available by the North Carolina Bar Association and Legal Aid of North Carolina as a public service. This video is for general informational purposes only. The video is designed for people who cannot afford to hire a private attorney to address their custody issues. The North Carolina Bar Association and Legal Aid of North Carolina make no assurances that this video will enable you to succeed in resolving your custody matter. The information provided in the video is general legal information. It is not legal advice. Legal advice is dependent on the specific circumstances of each situation. The information contained in this video is not guaranteed, and the information contained in the packet cannot replace the advice of a competent attorney licensed in your state. It does not imply that the North Carolina Bar Association or Legal Aid of North Carolina has agreed to represent you or provide you with further advice or counsel. No one from Legal Aid or the North Carolina Bar Association will appear on your behalf in court. In no event will the North Carolina Bar Association or Legal Aid of North Carolina or anyone contributing to the production of this video be held responsible for any damage resulting from the use of the video. This video is meant to assist parents who are preparing for a custody trial in North Carolina courts. Laws vary from state to state. If you are not located in North Carolina, or you are not a biological or adoptive parent of the child you are seeking custody of, the information in this video may not apply to your custody case. If you have any questions about how to prepare for your custody trial or how to present your case, please consult with a competent domestic attorney in your area. If you are separating or divorcing, your children deserve a conflict-free resolution to their custodial arrangements. It is almost always in your best interest and in the children's best interest if you can resolve your custody dispute without a trial. The court system is expensive and can take an extended amount of time. If you are unable to resolve your custody dispute through mediation or collaborative means, this video is meant to provide you with some insight into the court system and how your trial might proceed.
I filed my custody case, and my ex-partner and I have tried mediation. I have a custody case set for trial. What happens when I get to the courtroom on the day of the hearing?
In most courtrooms, a judge and a courtroom clerk are in the courtroom. The judge or clerk will call all of the cases on the calendar. Be sure that when you hear your name called, you answer loudly and clearly to let the judge know you are present. When the judge is ready to hear your case, the judge will call your name again and ask that you come forward.
After my case is called for trial, what happens?
Either you or your child's other parent, or both of you, may have filed the claim or motion for custody. If you filed the documents, you will go first when the hearing starts. If the other party filed the complaint or motion for custody, then they will go first. If both of you have filed claims or motions for custody, then the person who filed first typically goes first. The first thing you will need to do is present your opening statement. The opening statement is a brief summary of your situation. You should write down what you want to say in this opening statement before you go to court. The opening statement is only a brief summary of your situation. You will have an opportunity to provide more details later. You will want to include the following information in your opening statement: your name, the name of the other party, how you know the other party and if you are related to the other party, the names of children and dates of birth for the children, a short summary of what you will be asking the court to do about custody or visitation. This should just be a few sentences, including your overall concerns and what specifically you want the court to do for you and your children. After the first person presents their opening statement, the other parent will present their opening statement. Following that, each person will have an opportunity to present witnesses. This means that you and your ex-partner will have an opportunity to testify. A person who testifies is placed under oath and promises under penalty of perjury to tell the truth. The person is then permitted to talk and answer questions about custody.
How much time will I have to present my custody case?
Some counties will allow you unlimited time to present your witnesses and your evidence. Other counties will limit your time to the time you request when you schedule the custody hearing. Make sure you find out if there are time limits in your county and make sure you ask for enough time. Determining the amount of time you need for the trial can be tricky. The time includes the amount of time it will take you to present your facts and for the other side to present their facts. A good starting point is to figure out how long it will take you to say what you would like to say and how long it will take your witnesses to say what they need to say, and then double that time for the other parent. It's better to get finished in less time than you request than to run out of time to present all of your evidence.
Do I get a chance to testify in my case?
Yes, you may testify. Call your most important witnesses first. As a parent, you should be one of your witnesses. If you want to testify, consider testifying first to make sure the judge gets to hear what you have to say before you run out of time. This will be your only chance to tell the judge about your child and the things you want the judge to know. You may also want to call other people to testify who are familiar with your children and the other party. If you want to convince the judge that something is true, you may want more than one person to tell the judge about it. For example, if you think your child is being abused by the other parent, you will want to call a witness other than yourself who has seen this abuse to testify on your behalf. If you have documentary evidence, introduce those documents before your time runs out. If you have proof of something but you never show it to the judge, it will not help you.
What should I tell the judge during my trial?
In a typical custody case between a mother and a father, the judge is only concerned with the best interests of the child or children. Make sure you focus on custody issues rather than financial issues or your past marital problems. Remember that if you are not the biological or adoptive parent of the child at issue, there are additional things you must prove before you can ask a judge for custody of a child. For example, you will first have to prove that you are eligible to bring a custody case. You will also have to prove by clear, cogent, and convincing evidence that both of the biological parents are either unfit or have acted against their constitutional interest as parents. These kinds of cases involve different legal issues and are beyond the scope of this video. If you have questions about non-parent or third-party custody claims, you should contact a competent family law attorney in your area. Examples of things the court wants to hear about in a custody case between two parents are the children's educational performance and progress in school, the children's medical conditions and needs, activities in which the children are involved, such as school activities, sports, or other extracurricular activities, any concerns you have about the other parent's ability to care for the children, whether there has been domestic violence involving the other party or the children, whether Child Protective Services has been involved with your family, who primarily took care of the children before the parents separated and before you came to court, the work schedules of the parties, the current visitation or custody schedule, and the new visitation schedule you are asking the court to impose. There may be other information that's relevant to your case that is not on this list. Be sure to present it. The court will also want to see physical evidence or documents that support your position on custody. Some examples of documents that a court may want to see in a typical custody case are a photo of the children, school records, individualized education plans or IEPs, report cards, medical records for the children, certified criminal history for the other parent, if applicable, certified copies of any restraining orders involving the parties, safety assessments from Child Protective Services, emails between the parents about the children, calendars or visitation schedules used by the parents before court, and a school calendar for the school the children will attend for the upcoming school year. Before a judge can look at a document, you will have to tell the judge what the document is and who created the document. Once you've told the judge what the document is, you can ask the judge to look at it. Make sure you have at least 4 paper copies of everything you want the judge to see. You will have to provide a copy of the document to the other parent, to the witness, and to the judge. Do not ask the judge to look at your cell phone or your laptop to review texts, emails, or photos. You want to provide the court with hard copies of everything so that the court system has a record of what was given to the judge. If the case is appealed, only hard copies of documents will be included in the record for the appeals court. Unless directly related to custody, the judge will not generally want to hear about marital property issues, alimony issues, child support issues, marital misconduct, or affairs of the other parent during the relationship.
After I testify, can my ex-partner ask me questions?
Yes, the other parent can ask you questions after you finish testifying to the judge. You will have another opportunity, after you are questioned, to explain any further information to the judge before you finish testifying. Do not save any information for later during the hearing. If you have something you want the judge to know, you need to tell the judge the first time you are testifying.
How many witnesses do I need to have? And how do I decide who to call as a witness in my case?
There is no limit on how many people can testify. However, you may want to ask the judge if you have any time constraints before you have your witnesses testify. Additional witnesses should testify in order of importance so that the judge hears the most important information first. You can call anyone to testify in your case that has relevant information about your child custody action. The following people are often called to testify in custody cases: Child Protective Services caseworkers assigned to the case, neighbors or relatives who see the child and parties frequently, teachers or daycare providers of the child, counselors who work with the child, babysitters or people who take care of the child while you are at work.
Can my child testify?
It depends. Children are allowed to testify if they are old enough to understand what's happening and the importance of telling the truth. Older children are sometimes permitted to testify, but generally, judges prefer to avoid having the children testify. Sometimes, there is very important evidence that only a child knows or can testify about, but it's usually best for the child not to have to come to court. Most judges do not permit children in the courtroom. If you do want a child to testify, make arrangements to have someone sit with the child outside of the courtroom. Get permission from the judge before the trial starts. Have someone available to bring the child to the courtroom when it's time to testify, and to leave with the child when the child's testimony is over. If the child is not needed for the hearing, you should not bring the child to the courthouse at all, and certainly not to the courtroom on the day of trial. If the judge does permit the child to testify, the judge does not have to do what the child wants. The child's testimony is only one piece of evidence the court will consider in making its ultimate custody determination, which is based on the child's best interests and not what the child wants.
After my witnesses testify, does the other party get to present witnesses?
Yes, after the moving party's witnesses all finish, the other parent may testify and present their witnesses. You will have the opportunity to question any witnesses called by the other parent.
After both sides have presented all their witnesses, what happens?
Both parties may make a closing argument and ask the judge for what they want. If you filed the complaint or motion for custody, then you will go last. If the other party filed the complaint or motion for custody, then you will go first. The closing argument is your opportunity to make any legal arguments to the judge and to tell the judge what you want the judge to do about custody. Be specific. You should make notes for this portion of the trial. You should tell the judge the following information. Where should the child live? What days and nights do you want to have custody of the child? Who should make the important decisions for the child? What time do you want the exchanges of the child to be? Where do you want the exchanges of the child to take place? What holiday schedule do you want to have?
After the trial, how long will it take for the judge to tell me who gets custody of the children?
Sometimes a judge will issue a decision immediately from the bench while everyone is still in the courtroom. In that event, it still may take some time before the decision is reduced to writing. If one of the parties has an attorney, the judge may instruct the attorney to prepare a written order. In that event, both parties will have an opportunity to review the order and make comments about the order before it is signed. If neither party has an attorney, the judge will usually prepare the order and mail a copy to the parties. A custody order is not technically entered until it is signed by the judge and file stamped by the clerk of court. You will not be able to enforce the custody order until it is entered. Often, a judge will take a case under advisement and will not issue a decision right away. This may be because a judge wants more time to read the documents you've provided or to consider certain legal issues in the case. If a judge does not issue a decision from the bench, it could be days or weeks before a decision is rendered. The judge may have several cases under advisement at any one time. Once the decision is rendered, there may be an additional delay in reducing the order to writing. If you have not heard from the court about the order within about 3 weeks after the hearing, you may call the family court office or the office of the clerk of court to ask about when you may expect a ruling.
I had my custody trial and I am not happy with the judge's decision. What can I do now?
If you are not happy with a temporary custody decision made by the judge, you will have another opportunity at a later date to have a permanent hearing. If you have already had a permanent hearing and do not like the judge's permanent custody decision, you have several options after your trial is over. The first option is to request a new trial or ask the judge to set aside the order. There are deadlines that apply to these kinds of motions. If you have questions about how to request a new trial or ask the judge to reconsider the order, please review Rules 59 and 60 of the North Carolina Rules of Civil Procedure or speak to a qualified attorney. The second option is to file a notice of appeal. There are deadlines that apply to filing a notice of appeal. If you have questions about how to file a notice of appeal, please review Rule 58 of the North Carolina Rules of Civil Procedure and Rule 3C of the North Carolina Rules of Appellate Procedure, or speak to a qualified attorney. If you do not choose to appeal, you can still ask the court to reconsider the custody decision later if there's been a substantial change in circumstances that affects the welfare of the minor children and warrants a change in custody. The court will determine on a case-by-case basis what constitutes a substantial change in circumstances. If the court finds a substantial change has occurred, the court may modify custody based on what he or she thinks is in the best interest of the children. For more information, please see our other custody videos and documents located on the Legal Aid of North Carolina website.